Your Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to those watching on our Kansas Supreme Court live channel. I would ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Thursday, April 1st, 2021 consists of one case. Appeal number 121284, State of Kansas versus Casimiro, Nunez, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, will you please state your appearances?
Corey Call, appellate defender representing Casimiro Nunez, ready for argument.
It pleases the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, counsel. Mr. Call, you may begin.
May it please the court, counsel. In late October of 2016, Casimiro Nunez hosted a party at his house. During the course of that party, Mr. Nunez and Antonio Guzman got into a fight. One of the people at the party knocked Mr. Guzman to the ground, and Mr. Nunez shot him 3 times and killed him. Mr. Nunez then turned to a woman at the party and told her to call the police. And she did not, she ran. So he called the police. The police arrived. And during the subsequent search of the house, they found some methamphetamine and some scales. Mr. Nunez was charged with first-degree premeditated murder and possession of methamphetamine with the intent to distribute. He was convicted of both those counts. We raised 4 issues on our brief. The first was that the district court failed to give the requested instruction of involuntary manslaughter of a lawful act committed in an unlawful manner, which would be self-defense using excessive force. The second issue was a procedural error based on comments made by the prosecutor. Third issue was a cumulative error, combining those two, because those 2 errors combined to make the situation worse. And the fourth issue was that the district court erred in failing to grant immunity. Mr. Nunez had filed a motion for immunity pre-trial, and the district court denied that. On the first issue, Mr. Nunez at trial claimed self-defense. He claimed that Mr. Guzman had come at him with a knife and that he was defending either himself or his son. He didn't testify at trial. He gave statements to the police, really 3 versions, somewhat conflicting versions sometimes of the events. But the crux of it was he was acting in self-defense. And the judge instructed on self-defense to the jury. Mr. Nunez also requested an involuntary manslaughter instruction that he act in self-defense but used excessive force. The district court denied that instruction because the district court found that involuntary manslaughter requires an unintentional killing. And that's incorrect. This court has found that the statute used to be right, but the statute changed. So that was wrong. So here, the analysis is, was it requested, which it was? Was it factually, was it legally appropriate, which the state has conceded that as a lesser, it's legally appropriate. So the questions for this court are, was it factually appropriate? And if it should have been given, whether it was harmless error.
Counsel, if we jump past that and get to harmlessness, doesn't the jury's rejection of the self-defense claim by the defendant pretty well put all these arguments on the shelf?
I don't think so, Your Honor, because in order to find self-defense, the jury had to find that the force was reasonable under the circumstances. In one of Mr. What we know is that that there was a fight between the 2 of them, and that Mr. Guzman was knocked to the ground. And Mr. Nunez, in his last statement, told the police that he was reaching for a knife. So a jury could have easily found that Mr. Nunez still had the right to defend himself, but that Mr. Guzman was on the ground unarmed, and that it was excessive force to shoot him. And the state seems to be thinking that because he was on the ground, that Mr. Nunez lost any right to defend himself. And that's just not correct. This isn't a boxing match where if the person goes down or if you get some kind of advantage, the referee steps in and makes you stop. The jury could have found that Mr. Nunez could have gone to the ground and continued to fight in fisticuffs to punch Mr. Nunez, but he didn't have the right to shoot him, to fire 3 shots into him. Another problem, and this is where the errors kind of meld together. I don't want to move to the second issue yet, but is that we don't know why the jury rejected Mr. Nunez's self-defense claim. And it could have been they rejected it because they accepted the prosecutor's comments that it was Mr. Nunez started the fight. And so I think we know that they found him guilty and that they rejected the self-defense based upon the trial that they had. But I guess another point would be, I don't believe that self-defense and instructing on and the self-defense with excessive force are mutually exclusive terms. A jury, for example, in the Pullman, this court, the defendant said that he heard a gun cocked behind him and he thought someone was going to kill him. So he turned around and shot. And the jury rejected the self-defense in that case. But the jury said that this court said that it was still appropriate, it was factually appropriate to give the instruction because he had the right to self-defense. And I suppose a jury could find that, well, it's even though maybe you have a jury could find you have self-defense, but a jury could also find that you can't just turn around and start shooting. The two are not mutually exclusive. Moving to the prosecutorial error, the state made 2 comments in rebuttal, which were not supported by the evidence. The state argued, now think about this. What if the defendant was still waving that gun around? What if Mr. Guzman was still waving that gun around after Christina went to bed? Maybe, just maybe, Mr. Guzman saw it, said, knock it off. They get in an argument. What if Antonio was acting in self-defense, saying, hey, quit swinging that stupid gun around, He popped shots off earlier in the night. Maybe he was telling Mr. Nunez to knock it off. What if Antonio, all he did was insult him? Well, there's no evidence of that. There was evidence that Mr. Nunez had shot the gun earlier in the day, and that a woman, Ms. Jones, who testified, told him to stop doing that, and then she went to bed. But there's no evidence that he was waving the gun around before the incident. There was no evidence that shots were fired. There was no evidence that Mr. Nunez asked him to stop. There was no evidence that that's why the encounter occurred. And it's important. This is difficult for the state because Mr. Nunez was saying he attacked me. That is why this fight occurred. And
Mr. Cole, how far can the state go in suggesting possible scenarios based on certain evidence? There was evidence that there was a gun. There was evidence Nunez, your client, was shooting the gun earlier in the day. Based upon those, there's evidence to support that.
Sure.
How far can the state go with, you call it conjecture, but suggesting a scenario that would support their theory?
Boy, I'm not sure I have a clean answer, and I'm not sure that there is a clean. I guess I would have to say that there has to be some evidence, some testimony of the basis of what the court, what the prosecutor is saying, and it's insufficient that a few hours earlier we know that he was waving a gun around. I don't know if maybe if it was an issue that he was waving the gun around later, that the prosecutor would say, well, he waved the gun around earlier, and it's possible that he was waving the gun around later in the party. I don't know if that's good. Maybe that would be good, but certainly not that then Mr. Nunez objected to that, expressed his objections. Mr. Nunez became upset at that, and then a fight broke out, and Mr. Guzman was defending himself. That is certainly a bridge too far. If we can move, maybe a better example would be the second one that we complained about, where the prosecutor argues, what happened? Did Antonio go to buy drugs? Did they have a disagreement about price? I don't know. I do know there was a blue baggie, just like the one he has in his room, just like the ones he has in his spare bedroom, that's found in Antonio's pocket. Okay, so the police found a blue baggie of methamphetamine in Mr. Guzman's pocket. The police found similar blue baggies and methamphetamine in Mr. Nunez's bedroom, along with some scales. So it's possible that the prosecutor could argue that Mr. Nunez sold Mr. Guzman the bag of drugs, right? That nobody testified to that, but that seems to be okay. That seems to be maybe something you could do, but you can't say that there was a disagreement about the price and that therefore they got into a fight over about that. And this is especially bad because the prosecutor raised this at the preliminary hearing during the immunity hearing. As one of the reasons that they shouldn't be allowed immunity, that this was during a drug deal. And the judge, based upon the same evidence, told the prosecutor there's no evidence to support that theory. And yet the prosecutor, again, trots this out to the jury.
Is that really what happened? If a prosecutor is saying, hey, this could have happened, that could have happened, we don't know, but here's what I do know. Is that really misstating the evidence? I mean, it seems a pretty common sense way of communicating the opposite, that we don't actually know.
Well, I think as long as there's if it says we don't know what happened, and then they provide something that is supported, arguably supported by the evidence, even if there's no evidence of that fact. But the prosecutor cannot just make up scenarios out of whole cloth.
Why not? Why not if it's clear to the jury that it's just a hypothetical, essentially, and then the prosecutor immediately says we just don't know?
Well, because I think a jury, when a prosecutor is presenting a theory, they're doing so because the jury will accept that theory. I think that the problem is that a jury could not base its verdict on that speculation. If a jury said, yes, we believe that there was, that he was waving his gun around and that Mr. Guzman told Mr. Nunez to stop, and that's why the fight started. There's no evidence to support that theory. And so
would there be a difference if the prosecutor said something like, we don't know what happened, but I'm going to tell you what I think happened. This is what I think happened. Isn't that different from this could have happened, that could have happened, we don't know?
I think your scenario is significantly worse, I think. Although I think the impression to the jury is somewhat the same. I mean, we assume when I'm giving you my arguments, I'm saying this is what I think. If the prosecutor says, well, this could have happened, and it's still, even if there has to be some evidentiary basis for the prosecutor's statements, because the prosecutor is asking the jury to base its verdict on that statement.
Would you speak to the connection between the issue you're just speaking of, the conjecture scenario, and the first issue? You touched on it, that the only way that it impacts the request for the jury instruction and its denial based upon a factual recitation is based upon one of these scenarios. Is that what you were suggesting?
Well, I think if, as one of the problems that I have is that the jury did reject Mr. Nunez's self-defense claim. And that's one of the problems on the first issue. It's like, well, we wouldn't believe that. But the problem is we don't know why they rejected it. If they relied on the basis that for prosecutors' improper statements, then that would affect the first issue. And also, in general, it affects everything goes to the core of the case, the core issue of the case, which is, why did this fight start? Why were these two men fighting? And the state had to get around it. And so I think it plays on both issues in that way. If there's nothing further, I would ask this court reverse Mr. Nunez's first-degree murder conviction.
See no further questions. Thank you, Mr. Call. Mr. Maloney.
Thank you, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I also plan to focus my comments on the first two issues unless there are questions on the remaining issue. With respect to issue one, the requested lesser instruction, we do acknowledge that legally this was an appropriate lesser included instruction. However, our position is that the instruction was properly not given by the court because it was not factually warranted.
Well, do we have a problem with that analysis was not done by the district court? You concede that the basis for the reason of its rejection was the court found that it was an intentional shooting, and therefore the requested instruction of involuntary was not applicable. You concede that, correct? That was wrong based upon prior case law and then what we shortly thereafter opined in the next case. Do you agree with that?
Yes, I agree that the district court's analysis was based on an old legal theory that has since been proven incorrect. Yeah, we do concede that.
And so there really was no factual determination made by whether it was supported by the district court at the time of its request.
Correct. But I don't think that's a problem because, as in many cases, this is a scenario where the court would be able to analyze whether the district court's ultimate decision was correct for any reason. And I think specifically in this context, looking at the record now, this court is clearly in as good a position as the district court was at the time the request was made for the lesser instruction.
Well, then explain to me what isn't factually supported in the request for the instruction. It supports his defense. There was evidence, not just this isn't just a declaration by the defendant, hey, I was attacked, I was acting in self-defense. There were two other witnesses, one in particular that said, yes, he was attacked. There was a knife at his neck. There's bruising that would be consistent with that. Why isn't that sufficient in and of itself to support the instruction?
Right. Our position would be that obviously the defendant gave numerous statements, I think 3 in his formal interview, and he had also given one statement to an officer at the scene, and he'd also given a statement to 911. Our position is that while those statements were very inconsistent, including the fact that he initially claimed that his son was the shooter, we feel that when you look at those statements, the evidence that he is pointing to that he thinks would have supported this lesser instruction is in reality evidence that, if accepted by the jury, would have supported the self-defense rather than imperfect self-defense based on excessive force. In all of these various versions that he gave, he presented scenarios in which the victim was armed with a knife and or attempting to rob him and or attempting to gain control of the gun, either at the time of the shooting or mere seconds before. So if the jury accepts any of that evidence, that's a scenario where the defendant would have the right to use deadly force, not be limited to using ordinary force, which is to say less than deadly force. If the jury believes that the defendant has a knife to him or has a knife to his son's neck, or that the man that he's struggling with is in fact attempting to gain control of the gun, I don't see any scenario in which the jury would reasonably conclude that, okay, he could use force, but he couldn't use deadly force, that all he could do was either threaten to use force or display a weapon or do something other than actually use a gun to defend himself. I know
Counsel, doesn't the state's evidence lend support then to the defense's theory on the instruction then, that maybe the knife wasn't there at all? The stifling evidence demonstrates that it was more of an imperfect self-defense. Why don't we get to consider your response and your evidence at trial as well?
I think you do get to consider that evidence. Our position would be then that if the jury did in fact rely on the state's evidence and believed the state's theory of the case, the argument would be that there was no justification for the use of force at all, that this knife was in fact found outside the home some 20 feet away from the door to the house, that in fact it had nothing to do with the argument or whatever occurred that led to the shooting. So our position would be that if the jury did not believe the defendant's account that the knife was actually to his throat, it would be faced with a situation where there was no evidence indicating that the victim posed any threat whatsoever to the defendant, that it was simply...
Counsel,
yes,
wasn't there a box cutter, and wasn't there some evidence that one of the witnesses could have removed the larger knife after the shooting?
My reading of the record, it was a little bit unclear as far as, yes, there were two separate types of knives or cutting instruments, but the only knife that the defendant had ever referenced in any of his statements was a knife that matched the description of the weapon that was found outside the home, nowhere near the victim's body. The little device that was found clipped to the victim's jeans or pocket was not something that the defendant himself had ever referenced in trying to explain what happened or what type of weapon that the victim had displayed. So it's not entirely, at least from my recollection and reading of the record, it's not entirely clear how that knife got outside, but I think regardless of how it ended up where it did, and I think there was maybe some testimony and evidence that Your Honor is correct in citing that maybe that was moved by somebody, the fact remains that even if the knife had been inside at some point, there's no indication that the defendant ever saw that knife, let alone that he ever felt threatened by it or that he ever saw the victim display it. So the mere fact that there might have been another knife in the home at a certain point, I don't think is relevant in assessing whether this instruction was necessary, unless the defendant ever pointed to that knife as a basis for why he felt that he was at risk of death or great bodily harm, or even a lesser degree of force or damage to himself.
I thought there was physical evidence of markings on his throat that would have been consistent with the knife being held to his throat, which was consistent with the witness's testimony.
And I can't recall, I certainly trust Your Honor's recollection of that. I don't recall exactly what the nature of the wounds to his neck were. But again, to the extent that there would be knife wounds on his throat, I think that would further support our argument that such testimony would then allow him to use deadly force, not simply less than deadly force. If he had in fact had a knife to his throat, I don't think that any jury would reasonably conclude then that, okay, he could use force, but not deadly force. Nobody would expect a jury to say, well, okay, in that situation, you can threaten the victim or you can maybe display a knife or a gun, but you're not allowed to actually then use deadly force in defense of yourself when you've had a knife or some sort of a cutting object actually held to your throat.
But it seems like the weight of the evidence is that the victim had fallen to the floor and that the shots were fired then. But if there was some evidence that they were in the midst of a heated fight, and then any credit was given to Mr. Nunez's statement that the victim was still reaching for a knife, or then why doesn't the imperfect self-defense come into play at that point?
Sure. I think that's where we have to look at this in the perspective of how this would actually play out in the real world instead of separating it out. I think it's always tempting as an appellate attorney to be able to look at this on paper and view them as many distinct events and think to yourself, all right, well, if this person was on the ground, did he pose a threat that would rise to the level of imminent death or great bodily harm? But I think in reality, when you're looking at a fight like this, these things happen to the extent it played out in that manner. These things happen in a matter of seconds. And just because just because the victim might be temporarily on the ground, that doesn't mean that if this fight is ongoing and this struggle is ongoing and the victim is continuing to reach for the knife moments after having held it at the defendant's neck, and again, if you do credit the defendant's testimony, also believing that the victim had been struggling for control of the gun, I still don't think that it would be reasonable for a jury in even that situation to think to themselves that, sure, the defendant would have been entitled to defend himself with ordinary force, but he wouldn't be able to actually use a weapon to defend himself in that situation. I think that if you're truly in a situation where you've just been attacked and had a knife to your throat and had somebody struggle with you for control of a gun, while we might be able to look at it and say, well, the victim was on the ground, in reality, if you're the defendant in that situation and all of this has happened in a matter of seconds or moments, it would not be realistic to think that the defendant should then be expected to somehow use a lesser degree of force than deadly force. I guess just off the top of my head, one analogy that comes to mind is, I think we've all probably heard examples of studies or research that talks about in the context maybe of police shootings, how quickly it is that an assailant that is armed with a knife can attack an officer, even if they might be 20 feet away. And that doesn't mean that an officer then has to wait until the perpetrator is immediately upon them and actually has the knife at their throat. And so in this situation, if the victim is on the floor reaching for a knife and is in relatively close proximity with the defendant, which I think the physical evidence supports because there was the stippling from that final gunshot wound, I think that in that scenario, the defendant would not be limited to having to somehow use less than deadly force. I think that this really is a situation where for lack of a better expression, the all or nothing approach to this self-defense instruction was appropriate. He was either entitled to use deadly force because the victim had pulled a knife on him, held it to his throat, struggled for control of the gun, and was still trying to reach for that knife. Or if the jury does not believe that those events happened, then there would be no need for a lesser instruction on a theory that the defendant was entitled to use some lesser degree of force.
Could you move on to the second issue? And what concerns me is kind of the conjecture that the prosecutor engaged in based upon certain facts and took it to imagined scenarios. Is that permissible in anything? Here there was evidence also of underage females in the residence. Could he have surmised that, Nunez, that the victim Guzman was there to protect underage girls from engaging in unlawful acts with Mr. Nunez? I mean, how much are we allowed, or are you allowed to just offer explanations to reduce what is the actual evidence, or to at least offer different scenarios as to what the actual evidence supports?
One way in which I agree with opposing counsel is that I think that there is no bright line cutoff point for that. I think it always will be something evaluated on the facts of a given case. And I think clearly there does have to be some evidentiary basis. So in this case, for example, there certainly was evidence of the earlier gunshots that the defendant fired. And there was evidence that at least one party goer had told him to stop and made it clear that she was not happy with him behaving that way. Likewise, there was also evidence supporting the fact that this could have been that there was a drug transaction that was taking place. So I think that when you do have some evidence that supports it, and I think that tying in with Justice Stiegel's questions, when you have a situation like this where admittedly we don't know for a fact what caused the fatal shooting, we simply don't. And obviously motive is not an element that the state ever has to prove, but it's also something that clearly from a common sense, real world perspective, jurors do wonder. And so I think that when you have evidence that indicates that yes, there were drugs involved, there had been prior gunshots, I think that then from that evidence that what the prosecutor did here was fair comment and fair inferences based on the evidence, especially, again, to link in with what Justice Stiegel questioned earlier, especially because the prosecutor made very clear that he was not, in fact, suggesting that he knew that this was happening. It was what caused it, or that he personally.
Argument be based upon evidence, or at least some reasonable inference from the evidence, and not just idle speculation. I don't know, but it could have been this. I don't know, but it could have been that. Doesn't at least have to tie into what we do know? And well, we don't know that there was any drug transaction. In fact, there's no evidence of that. And that's why the district court rejected the felony murder at preliminary hearing. It just seems to me that to allow and to give, if this case stands for the proposition a prosecutor can speculate about anything, that's getting into dangerous territory and then goes into impact other parts of the case, like Mr. Cull is suggesting on the first issue.
Yeah, I would respectfully disagree as far as the drug evidence. And in fact, I think in his brief, the defendant himself acknowledges that there was evidence suggesting that the defendant had purchased drugs that the victim had purchased drugs from the defendant. So I think that there certainly was evidence that would support.
Okay.
I cite to page 21 of the appellant's brief, and certainly there was all sorts of evidence indicating that there were drugs in the house and that there were also drugs found on the victim. So I think now certainly we don't have specific proof that those drugs had been purchased by the victim that night, but that's certainly some evidence that would allow the prosecutor to make a reasonable inference there. And likewise, we do have this testimony from Miss Jones that the defendant had been firing the weapon earlier. And I think that's what contrasts those two scenarios from the hypothetical that Your Honor mentioned with respect to underage girls. There we have testimony that there were females in the home. We don't have any testimony that the victim or anybody else in the home had ever expressed any unhappiness with that or unease with that. We don't have any indication. I can't recall off the top of my head whether there was in fact evidence that these girls were underage, but we certainly don't have the level of evidence on that issue that we do showing that there were drugs, that there was quite possibly a transaction between the defendant and the victim, and that the victim had been in the home while this earlier random firing of the weapon occurred. So I think that when you combine that factual basis, that evidentiary basis, with the fact that the prosecutor very clearly in both of these comments acknowledged that he was in fact just presenting possible hypothetical scenarios based on some evidence that had been presented. And so I think that, yes, in that scenario, the case law does say that a prosecutor is allowed reasonable inferences based on the evidence. And here we did have evidence indicating drug transaction. We did have evidence that he had earlier fired the weapon. I think from a common knowledge standpoint, we all agree, and I think all jurors would likely have this common knowledge that in drug transactions, it's not uncommon for the parties to have a disagreement about price or have some other disagreement about the transaction that lead things sideways. So based on that evidence, I think that what the prosecutor did here was appropriate, especially again, because he did couch this by acknowledging that he did not know that this was specifically what happened. He was not suggesting that it was his personal belief that this is why the shooting happened. He was just pointing to one or two possible scenarios that were possible. And again, we all know that juries do wonder. They do question these types of things, even though motive is not an element that has to be proven. So I think in this scenario, the prosecutor was simply tying to the evidence and presenting two possible motives for it, but made very clear that he was acknowledging that this was not something that we knew with certainty. So I think that based on how he phrased it and based on the evidence that had been submitted, that it was appropriate to make these two remarks.
As you point out, context is often what we look at in these cases, to look at what was the context of the argument. And here, the context is that the prosecutor is telling them why they shouldn't believe Mr. Guzman's version of the facts. And he sandwiches these hypotheticals between statements that Mr. Nunez's statements just don't hold up to the facts. And after he gives this hypothetical that you just focused on, it's like 3, 4, 5 sentences later, he says the defendant's account breaks down in light of the evidence. Given that context, is it more troubling? And why shouldn't it be more troubling?
I guess I'm not entirely following your question, Your Honor, as far as why that statement would make the hypotheticals more troublesome.
Well, it seems to me that the context may make it sound more like this is evidence. This is the evidence. I know, I agree. He says maybe, just maybe Mr. Guzman saw it and said, knock it off. But the rest of it is not couched that way. Then it goes from there. They got in an argument, things like that. Some of those statements are qualified by maybes and some are not. It seems to jump back and forth between hypothetical and what might not be. But as I said, then sandwiched with these statements, the accounts breaks down in light of the evidence.
Right. Well, I think there I would just say that to the extent that the comments that the defendant has focused on are comments in which the prosecutor did use the hypothetical language and did make clear that this was not something that we knew with certainty and that he was just making inferences from the evidence. So I think that to the extent there were other portions of the argument in which the prosecutor appeared to speak with a little more certainty, if anything, maybe that just further highlights the fact that the jury would have been aware that these particular comments were, I don't want to use the word speculative because that would suggest that there was no evidentiary basis for the comments. And again, my position is that these were reasonable inferences. And I think that case law obviously accounts for the fact that there are going to be in most trials, there will be certain evidentiary issues that are very clearly proven or established at trial. And then there will also be things where you've got some evidentiary basis that might explain certain portions of things, but also leave open the exact way that other issues played out. And here, I think, it is, again, we don't dispute the fact that this is not a situation where we know exactly why it happened. We don't have any witness that came forward and said, this is why they were arguing, or this is why the shots were fired. I guess to some extent, we don't even know for certain that there was an argument. It's certainly possible that the defendant just shot the victim for no real reason at all. There are plenty of things in this case that are unknown, but again, I think that because the prosecutor's two examples or two scenarios that he pointed to were linked to evidence, and I think I would concede that if the scenario that Justice Rosen, if that hypothetical had played out, I think that would be an example of a scenario where that would be a prosecutor probably going too far. There would be simply nothing in the record that would indicate that the age of the girls there had anything to do with any type of a disagreement that might have happened between the victim and the defendant. But because there is evidence of drug use and a transaction, and because there is evidence that the defendant was firing a gun earlier and that the victim was present at that time, I think those are the types of inferences from the evidence that are appropriate. And I would certainly argue that if this court, even if this court were to disagree with my position on that, I would argue that the comments were harmless. And I would simply incorporate the harmless error analysis that I detailed in the brief. This is a case where the defendant gave so many conflicting statements, including the fact that he initially named his son as the shooter, and then only grudgingly admitted that he was in fact the trigger man. Then he gave one version about who it was that the victim was holding at knife point, and then finally acknowledged that his son was not even at the house at the time of the shooting. So I think from a real world perspective, the defendant had little to no credibility in the eyes of the jury after giving all of those statements. And I don't think that these two statements made by the prosecutor are the type that would have affected the verdict in any way. And I know I'm well past my time, so I will defer to any further questions from the court. And if there are none, would simply argue that the district court's rulings and the defendant's conviction should be affirmed.
I'm sorry to drag this out, but I want to nail you down on one thing, which is the statement by the prosecutor, this question by the prosecutor that said, did they have a disagreement about price? That specific comment. Do I understand your response to be, people just know that sometimes out in the world there are disagreements about price in a drug transaction, as opposed to anything in this case that you can tie, any evidence in this case that you can tie to that statement?
I think that's part of my argument, that I think that jurors would have enough common sense knowledge to understand that oftentimes there is a disagreement about price when it comes to drug transactions. That certainly weighs into my argument there, in light of the fact that.
But counsel, what facts in this case point to a disagreement about price? Because what I hear you telling me is that jurors know that there could be disagreements because they've seen episodes of Law and Order or Miami Vice. And I'm not sure that justifies the prosecutor making a statement, because it would, if that's the basis, it's just as legitimate to say people buy drugs all the time and don't disagree about price. So, I mean, again, I want, is there something in the record that indicates a disagreement about price?
Well, I think that the evidence in the record, the defendant's own theory, as he put forth, I think from the first phone call, from the 911 call, he did repeatedly indicate that the victim was trying to rob him. So I think when you have evidence of drugs, both in the house, and I think the testimony in the record indicates that the defendant acknowledged that he knew that there were drugs in the house. I think he maybe that was part of his various versions. As I think at one point he tried to act like he never sold or used drugs and that they were maybe somebody else's. And then eventually he did acknowledge that he knew the drugs were there and were his. So you have that. You have the fact that drugs were found in the victim's pocket, and then you have the fact that the defendant is saying that that the victim was trying to rob him. I think all of those things combined indicate that both drugs and money were issues that the jury heard about in this case. And so I think when you hear testimony indicating that there was quite possibly a drug transaction, and then indicating that there was an attempt to rob, I think combined those two things would allow the jury to reasonably wonder, even if this statement had not been made, to conclude that there very well may have been some sort of a disagreement about price. And I do think, and I understand Your Honor's point that, do we really want to just assume knowledge from TV shows or from something outside the courtroom? But I do think that we know that jurors, it's perfectly appropriate, and we in fact instruct jurors that they're allowed to decide cases based on their common knowledge and common sense. They don't have to check that at the courtroom door. So whether it's through a television show or reading actual news stories, I don't think it's a stretch to say that most jurors would understand that these types of transactions are something that oftentimes do end up with some sort of a disagreement. And so, again, combined with the fact that the prosecutor acknowledged throughout this comment that this was an inference from the evidence, that this was not something that he had specific evidence. There was no specific witness that testified that they overheard a disagreement or that they knew for a fact that there was a disagreement about the price of any drugs. But when you look at all of that evidence and then do allow for some modicum of common sense here, I do think that comment was appropriate, and that there was at least some bit of evidence that would allow the prosecutor to argue that was at least one possible reasonable scenario that led to the argument that ultimately turned fatal.
Any further questions? Anything else, Mr. Maloney?
No, Your Honor, we would just simply ask that the defendant's convictions be affirmed.
Thank you.
Thank you.
Mr. Cole, you reserve 3 minutes.
Thank you, Your Honor. Unless this court has any questions, I think we've covered everything that I wanted to cover.
Any questions? Okay. Thank you to both counsel for your arguments this morning. We will take this appeal under advisement, and we are in recess until 11 o'clock this morning.